बोला नहीं इसी में चीज पाई जा सकती है मोबाइल
Speaker, Lordship, permission may mention item 23 only. Your Honor, disposing of on the premises that is a partnership firm is given is not a partners can be prosecuted.
We have only said that direction.
But my lord, your Lordship is the held that the prosecution will go on against the partners. But my lord, I have a judgment also got to bring to your notice.
Made the order now. Let it go on, you can show it to the concerned court now. But we use this before the concern.
But this is quite court, my lord, it says there. But that's why I just want to bring to your orders.
No, sir.
Your Lordship, I am a witness for this point. Your Lordship, please issue me a commentator since there have been bereavement in the Admin Council's family.
See, who is the counsel?
Somebody in the same.
If by the state as a petitioner, notice has been served on the state council as well as on the complaint, defaulter complaint. Defaulter complaint has been made appearing. Meanwhile, we are ready with the 20.
Who is the complainant?
Complaint has not appeared today. That question.
So, when is it likely to return the counsel?
Your Lordship, 1 week time period.
But we have that, the career account that we have DD. But the Rockford career account that we have DD will not be given to them. That is balance amount for 20 lakhs. DD we have. Secondly,
You have it with you, you keep it.
but
You keep the DD with
yes, we only one small submission. Now the matter is before the Honorable Magistrate, but he has recorded last time. It is an admitted fact that the proceedings of this case have not been stayed with the Honorable Supreme Court of India. Therefore, he says, it is clarified.
What is the date of the order? What is the date of the order?
For this date of the order 10 to 2023. He says, it is clarified to the Honorable Counsel of the accused that in case proceedings before this court are not stayed till next date, this court shall proceed to hear all.
Show the order. Show the order.
We wait till it okay.
But the complainant's counsel is not here. Where is the complainant's counsel?
It is not here.
Service is completed.
We have paid it out.
Presented before the trial court. No?
Yes, sir.
Immediately after registration, someday. In the meanwhile, proceeding, the trial court shall not go ahead with the pending proceedings. Complaint number, what is the FIR number?
No, the CC number.
CC number.
CC number. Sorry, but I have to the number. CC number. CC number 78 of 2014.
2014. Say, arising of this number. First, like should be when the counsel appearing on request for adjournment is made on behalf of counsel for the state. Submitted that he has suffered at the next is state that must be continued to the next state of hearing. List the answer.
Great. I can forget it.
Wait. The office report indicates that XCD has left without instructions.
I am appearing for state. Respond number 2 is XCD.
What's your instruction in this matter?
Okay, NCB is the main party. They have made an application for.
No, state is actually not a necessary party because the
You want your passport back for a foreign travel?
foreign.
What foreign travel?
I had indicated at the point in time when I had asked for requested for it, there was a meeting for which I was expected to go. But
It's now over now.
it's not over.
What is the state of the trial now?
Not even charges have been framed.
I'll have to seek instructions for that. Perhaps may issue fresh notice to NCB also.
There must be somebody appearing on behalf of the NCB.
Usually an ASG appears.
The union is to inform either Mr. Natraj appears or Ms.
Party appears.
And then call somebody on their behalf and give a date.
This issue has already been decided against the revenue tax. It is reported that of cases are empty.
This is 41.
$40.
245 HA. The High Court has read down the provision settlement commission.
Appeal is dismissed. The issue in question has since been decided in the judgment Optical Union of India versus Star Television News Limited, 2015, 12 SCC 665. So, the present specially petition is dismissed in terms of the said fact. Especially petitions are
We kindly seek a password in 1932.
password 2016 man. Who's appearing?
Lordship Senior Advocate Dr. Manish Singh.
But Item 43, we circulated a letter, Madam, says requesting for permission to file an adjournment.
Adjournment request of the petitioner. Petitioner is permitted to file the adjournment.
Obliged.
Item 44.
44. ESSP. Yes.
And for respondents. So we need to contain below filing of the waited for 5 years. But it doesn't perhaps later, and they filed in the review.
Section 44 and requesting for a week's recommendation.
No, nothing, we're dismissed.
Milords,
This is complete abuse of process.
Milords, grant me a week's time at least.
Why?
Because the argument counsel is not in town because his mother is unwell, medical emergency. Because I'm requesting a
Who's arguing?
money with some in area.
Complete abuse of process. When is he coming back?
Milords may have it this Friday.
Chalo, keep checking. At request of counsel for the petitioner who submits, it is submitted that the petitioner's counsel is unable to attend the court on account of indisposition and of his mother. First for adjournment. Because specific date.
After 45,
Please. And I'm appealing for the respondent. What the 5 months less are. And I think there is a letter circulated.
after 46,
Lords, I appear for the petitioner in item 49 pursuant to my Lord's I have appear for the petitioner, my Lords, pursuant to my Lord's directions. They have filed an
File is affidavit.
My Lord, I have only one request, my Lords. My Lords, let the daughter's relationship with the father continue. I'm not seeking any specific orders, my Lords, but let there be a direction that the mother will facilitate phone calls and as and when the daughter is comfortable, may meet the father because she's 13 years old, my Lord. Let her not be deprived of her father's presence in her life.
I want to say one Professor Babu. When I was in Calcutta High Court, my senior is a Purban Mukherjee, who was in Calcutta High Court, and that Chief Justice of the High Court, he gave me first suggestion. In my table, I had to settle. Called me, I received this advice by Ashwan senior, that I know.
Mr. Gupta, what do you say?
From who? Can be. Things, see, bonds were not, but he got all his personality takes. See, he never went to school, my son. He will only ask for the time of and asking me. My father, no, father deathbed. My mother died. Now I go to Buddha.
See, today,
I want to end them.
see, the point is both of you are fighting.
But I
Both the husband, the spouses are fighting.
will.
But ultimately the daughter
I
remains.
will take care. After he sees me from my childhood.
So now, let me complete this work. Mr. Gupta and I have no idea. Mr. Gupta, you have taken care, nobody is disputing that.
I will take it.
You will take care, definitely.
I will bother.
Alright, just listen for 2 minutes. After all, when the child grows up, she will need the assistance of the father. If she wants to become a doctor, or she wants to go abroad, or she may need financial assistance. So, at number one, at some stage she may actually want to have some link with the father. So let the fight between the two spouses, we are ending today, not also end the relationship with the father. If the father wishes to talk to the girl and interact with her, and she is willing to do that, to facilitate that. So we are fighting.
Recently, my Lords, as
What do you want? I want that. What I do,
my daughter, and because I have perceived there's an emotional bond between us.
you for your claim to what? I think 30 years. He never felt care.
That may not be true, my Lord. There is an interim order of the High Court that we were to meet with my Lord.
He was all my. He was school me.
That may not be true, my Lord. It's
He was
confidential.
I want to let.
And
I thought more
it's trusting that
I
I
got
will
my mother.
every
My
month
brother.
as and when the daughter.
Let me give you some peace of life. 30 years, 30.
Daughter may not be deprived of my presence, my Lord, in her life.
Yeah, ultimately, when tomorrow, God forbid, something happens, the only blood relative that way would be the father. The father, let us not alienate the father completely. He has his responsibility, legal responsibility. And if he is willing to now establish something, it is not too late. It is never too late.
Very good design.
My Lord, High Court has granted me visibility.
Very good design. Knew that design.
This arrangement
But
is still COVID.
30 years never came.
So, my
I
Lord,
have to clear the whole thing.
that's an order of the High Court granting me visitation.
No.
It was complied with, my Lord, still prior to COVID. After COVID, it has not been complied with, my Lord, because the mother has refused to even let me speak on the phone with my daughter, Lord, let alone comply with the order.
Please make an observation, but don't come back with some application or.
My Lord, that's why my request was not for any specific order or direction, my Lord, just that
I would-
mother should facilitate phone calls as and
I
when.
don't work for that. I don't work for that.
My Lord, will ascertain the daughter's wishes then, my Lord. She is 13 years old and there is a bond between me and my daughter, my Lord.
What's the harassment to you?
No, I know he is right.
Mr. Gupta,
Very powerful man,
Mr.
money
Gupta,
man. My But
We know each other, we only represent clients, we should not come in the way and become their mouthpiece.
certainly, but I agree to that.
A certain the daughters.
What is all this? Ultimately, if the daughter wants to talk to the, you can't be so.
To visit the house,
Look, my lords, I am requesting for
What is
phone
that?
calls and video calls as and
now
when.
the man is going to be a
I am not requesting for any order.
Sit down. These parties have moved, this is a joint application.
My
No,
lords,
no.
it's by him and I have consented to it.
she lost in the High Court, and I compared to that is a pity. No other way.
What is the application? IA number 1064.
106407.
This is an application by the respondent wife seeking a direction to dissolve the marriage parties between the parties. So, this court should notice to explore the possibility of a mediated settlement. So, during the pendency of these proceedings, the respondent wife has moved the present application. So, counsel for the petitioner has expressed no objection to the grant of the claim for dissolution of marriage in exercise of this court's power under Article 142 of the Constitution. So, next paragraph. Learned counsel, on the previous date of hearing, learned counsel for the respondent had submitted that the request for, you would ask for alimony, no? For alimony will not be pressed. So, court had required the filing of an affidavit to that effect. So, the respondent has in fact placed an affidavit to that effect on the record. Next paragraph. The parties, a daughter named, what is her name?
Pitra.
Pritha Sarkar.
Pitra. But he is old.
Was born out of wedlock. She is currently aged 13 years. So, the next paragraph, having heard counsel for the parties, court is its opinion that the agreement arrived at whereby their marriage will be dissolved is voluntary. So, the counsel for the petitioner husband has requested that the court may make certain appropriate observations or order with respect to the interaction between him and the daughter who is in the custody of the respondent's wife. So, this court is of the opinion that even the question of custody has not been agitated, the request is, and given the fact that the respondent's wife has been responsible for the upbringing of the daughter, nevertheless, it would be in the fitness of things that if in a given situation, the daughter expresses the desire to interact with the father, she should be allowed to do so.
And also conversely, I am not written.
Likewise, in case the petitioner seeks to establish links with the respondent, with the daughter, with his daughter, the respondent would react positively and facilitate the process. Paragraph. Subject to the above observations, the court hereby dissolve the marriage of the parties in exercise of its jurisdiction under Article 142.
Wait, my lords, one more observation, my lords. We direct her to share her telephone number with me, my lords, because she is not reachable, my lords, and the number keeps changing.
One point. For 1 year, he is not giving me my daughter.
My lords, I can show from records that.
1 year.
I can show.
I could order.
I'm pressing my application.
Yeah,
I can show.
yeah, counting and fighting. It's very bad speed.
Water under the bridge, my lords, I can show everything from my
Very bad speed.
It's no, my lords.
See, what page is my daughter?
the invitation and including the sharing and her number. So likewise, the petitioner shall also take appropriate steps to remain in touch. Periodically, remain in touch periodically, preferably once a month.
Great. Will also be directed to share the number with
Yes, yes, yes.
Great.
Will you please provide the number? Tell us.
Actually, no.
Great.
Then in order to, I know, so I was telling about.
Yes, yes.
But
No, that-
why he is not given for 1 year? No, or not given. Case is
I
pending.
was not to open the case file and add the That's not true, Milords.
Number, item 47.
Great.
100.
Yes, Alex, this was the matter I was mentioning. Learned AG is leading me, Alex, he's in some
Government survived because the issue of Tuamotu is now in central.
Yes, Alex. On Suomoto, there were two issues that we raised actually. There was one Suomoto which goes against, Alex, which goes against us. The second issue is, Alex, jurisdiction of NGT under section 17, whether it's stand out.
Why is compensation, etc. Why should we keep that issue open?
Alex, because this issue will have to be decided, Alex.
Will be decided in future. We'll flag that and keep it open.
Alex, what we are saying is, if my lords in the end are not convinced with on the aspect of compensation to them, my lords may grant compensation to the defendants, but decide the issue of law. That is, my
The
lords.
question is, if it's a plain issue of law like this,
Yes,
we'll keep it open.
but my lords, then it should be decided now because
Why should we? I mean, this is gross case where you see, we might actually decide the other way. Why should we say that?
yes, my lords.
If this is not a normal, I mean, what was the,
My lords, the issue was they were repairing a pipeline, my lords. There was a pocket of CO2 over there, my lords. They removed their masks while talking to each other. And therefore, my lords, they inhaled CO2 and died on the spot, my lords. Before,
please do not invite in order.
my lords, I'll be able to show from the record, my lords.
You may be able to show, but still we may uphold the order.
My lords,
And that in law it will prejudice. Why
my
should
lords, that prerogative is always with my lords.
Not a question of prerogative, it's ultimately what is right.
Yes, my lord. So that's in law, my lords, if we can show. My lords, in law, I can show, my lords, that section 17. But to my lord,
Decide it right now, please ask.
my lords, I was requesting.
So please, this has gone on, this has been, last time also you did the same thing.
No, my lords, I briefed the learned AG, my lords, I got a
The
message.
AG has not come.
As my lords, then I will make my submission. Would my lords first kindly take up section 17 of the NGT Act?
National Green Tragedy Act.
So set it out at page 74.
Yes, 74.
May I just place it for my lords? Where death or for injury to any person other than a workman. So my lords, there's a clear exclusion that if death or injury is to any person other than a workman, or damage to any property or environment. My lords, in this case, damage to property or environment has not occurred. There is no such finding of the tribunal, my lords. Has resulted from an accident or the adverse impact of an activity, operation or process under any enactment specified in Schedule 1, the person responsible shall be liable to pay such relief or compensation for such death, injury or damage under all or any of the heads specified in Schedule 2 as may be determined by the tribunal. Now, my lords, it's our respectful submission, my lords, that legislature has specifically excluded workmen and workmen has been defined, and I'll show that. The reason being, my lords, legislature already has in place two specific and special enactments, being the Workmen Compensation Act and the Employee State Insurance Act, which prescribe and provide for in the event of death or injury from accidents to workmen while at the workplace. They provide for a manner in which compensation will be determined and paid to the workmen. So in this regard, if my lords will now kindly just see section 2O of the NGT Act, my lords, which is at page 70. 70. Right. Now, my lords, it says workman has the meaning assigned to it in the Workmen's Compensation Act 1923. So to see whether or not these people were workmen, you have to go to the Workmen's Compensation. Yes, ma'am.
Under the Act,
Yes, ma'am.
the jurisdiction of the damages, the grant damages or relief is not structured. Is it structured or not?
My lords, it is structured, my lords, in a manner of speaking, it is structured. Yes, my lords. If my lords would first see two broad headings are given, my lords, the national being of
Structured in the sense that like we have in Workmen's Compensation Act, or motor vehicle tax. We have
or there are my lords, in that, if that's the query, my lords, no, there is no such formula provided. It will always be based on the law, my lords, that what is the loss or damage law.
social.
Yes.
Social tax.
That's right.
Therefore, there is no structure, which means that the tribunal is free to choose the method and the quantum. Right? Whereas in the Employees Provident Fund, something not a Workmen's Compensation Act and the Employees State, there are caps, which means that legislative is a class. If you want us to invite on that classification, we have no problem, even though it's enough. We will. You will press this, we will.
My lords, I'll show judgment.
That classification, we will.
My lords, I understand that.
Pressing it, we will. It's not a threat, because prima facie it seems that this is completely irrational.
No, my lords, I'll show that, my lords, why it will, if my lords.
There are two people, one inside and one outside.
Yes, my lords.
According to the law, the one inside will get a structured compensation which will be far less than what is given to a person who stands outside who is not a workman. Let's say somebody inside the premises who is not a workman. No, he may be an employee who is not a workman. He will get more. I hope you follow.
Yes, my lords. May I respond, my lords?
Workman has a certain connotation. Contractors, employee may or may not be. A managerial staff will get far higher compensation. Workmen will get what is there under the law. We'll have to see that.
Yes, my lords. So may I respond to that, my lords? Because that's a pertinent question my lords have placed, put to me, my lords. My lords, even under tort, my lords will always go by a principle as to how that damages will be computed. Because my lords have said even in personal injury matters, it does not mean that there will be a windfall gain. There will still have to be some aspect on which the damages are computed, which my lords have always taken as what was the person who has died.
You thought, I doubt whether you.
Yes, my lords, that's, my lords, I'll show those line of
We
judgment.
don't have a structured law in thought. If it were, I mean, it's very important that we should, because then you can go into general damages, special damages. And, the scale can increase.
Yes,
But we don't have, we
Right.
do more of an ad hoc, it's more of an ad hoc exercise in the case. Whereas in a structured one, you actually go into the income.
Yes.
Then we have also artificially, judicially imposed caps, etc.
so my lords, in tort, as you, my lords know now, there's some legislation which deal with tort liabilities like the motor vehicle accident.
Even this is also torture.
Yes, my lords, my lords, the Consumer Protection Act.
Of the general tort.
Yes.
In general tort, there is not much structuring happening in India.
My lords, my lords are right that there is no specific judgment on the aspect of what is the.
We have not developed tort jurisprudence.
To that extent, yes, my lords. Now, my lords, my respectful submission there was, my lords, as the law stands today, my lords may develop the law. My lords, as the law stands today, even in tortious liability, my lords will always still go by the concept of by far section 73 compensation, that means putting the person back into a position that person would have been in the event that accident or injury had not occurred. That is how my lords have till now interpreted these laws. Now, my lords, if given that aspect of the matter, my lords, we in the Employees State Insurance Act also, my lords, what is seen as their wages, my lords, and that wages itself is being paid. So in my respectful submission, there won't be an unreasonable classification here. I will be able to show that if my lords permit me. And my lords, insofar as tortious liability is concerned, this issue specifically arose before this Honorable Court in 1997, throughout the ESI Act, where my lords, under the Employee State Insurance Act, the employee obtains the benefits and then sued for tortious liability.
That was there, didn't have the NGT.
Yes, my lords, not the NGT, my lords, it was a suit for tort, my lords. So, my lords, on the principles of
Probably because you have a law, you would say that that stands excluded.
yes, but my lords, that's the test, or that's, my lords, what we are today playing, that section 17 still, my lords, the legislature still wanted to keep workmen as a separate classification. Yes, my lords, the judgment, my lords, is 1997, 7 SCC 638.
This is Armstrong said.
My lords, this is Justice Majumdar and Justice Kirpal, and authored by my lords, Justice Kirpal.
1997.
1997, 7 SCC 638. This is, my lords, though NGT was not there, this is on the general principle, section 53 and tortious, if there's a tortious liability, whether it can.
VSC.
Please, my lords. I'm so sorry, 1997, 7 SCC 638.
From the other claims available under law.
Well, I just paste the facts from the head note if my lords permit to do, instead of reading 2-3 paras for the facts, my lord.
Yes.
My lords, from the head note itself, my lords, the respondent was an employee in the plywood factory of the appellant company. While feeding the DAP compound in the roller mill by pushing the same with his hands, the respondent met with an accident. However, he was allowed by the appellant company to continue in service without any reduction in remuneration. While still in service, the respondent filed an application in civil court under Order 33 Rule 1 seeking permission to file a suit. This application, also in view of Section 53, was dismissed by the trial court, was held by the full bench of the High Court to be maintainable. Opposing the instant appeal, the respondent contended that Section 53 should not be construed in such a way as to prevent an employee from bringing about an action in tort. So that was the test, my lords, the query that was raised before this honorable court. Then if my lords would kindly see para 10 onwards. Para 10 and 11. And I'll place Section 53 and 61 also for my lords' consideration, which is referred in para 9. Para 10 if I may place my words. May I place para 10 onwards?
Yes.
The position with regard to the claim of an employee against his employer on his suffering an employment injury now stands settled with the decision of this court in A. Trehan versus Associated Engineering Agencies. In that case, Trehan, who was an employee of the respondent, received injuries on his face while he was carrying out repairs of a television in the course of employment, as a result of which he lost vision in the left eye. After receiving the benefit from ESI Corporation under the ESI Act, he served a notice of the respondent demanding rupees 7 lakhs as compensation. Thereafter, he filed an application under the Workmen Compensation Act claiming compensation of rupees 1,06,000. The employer objected to the maintainability of the same and relied upon Section 53 of the ESI Act. The Commissioner overruled the employer's objection and followed the judgment of the full bench of the Kerala High Court in the present case and observed that ESI being a welfare legislation, Parliament could not have intended to create a bar against the workmen, claiming more advantages benefits under the Workmen Compensation Act. The single advantages benefit and the single judge of the High Court dismissed the writ petition filed by the employer, but the division bench in appeal held that in view of the bar created by Section 53, the application for compensation filed by Trehan was not maintainable. This court analyzed the provisions of Section 53 of the ESI Act and observed that so as follows. In this background and context, we have to consider the effect of bar created by Section 53 of the ESI Act. Bar is against receiving or recovering any compensation or damages under the Workmen Compensation Act or any other law for the time being in force or otherwise in respect of an employment injury. The bar is absolute, as can be seen from the use of the words shall not be entitled to receive or recover, whether from the employer of the insured person or from any other person, any compensation or damages, and under the Workmen Compensation Act or any other law for the time being in force or otherwise. The words employed by the legislature are clear and unequivocal. when such a bar is created in clear and express terms, it would neither be permissible nor proper to infer different intention by referring to previous history of the legislation. That would amount to bypassing the bar and defeating the object of the provision. In view of the clear language of the section, we find no justification in interpreting or construing it as not taking away the right of the workman who is an insured person and an employee under the ESI Act to claim compensation under the Workmen Compensation Act. We are of the opinion that the High Court was right in holding that in view of the bar created by Section 53, the application for compensation filed by the applicant under the Workmen's Compensation Act was not maintainable. Then, my lord, I go straight to para 11, my lord. In view of the aforesaid observation in Rehan's case, with which we respectfully agree, it is clear that the respondent could not make a claim for damages. Section 53 disentitles an employee who has suffered an employment injury from receiving or recovering compensation or damages under the Workmen Compensation Act or any other law for the time being enforced or otherwise. The use of expression or otherwise would clearly indicate that this section is not limited to ousting the relief claimed only under any statute, but the wording of the section as such that an insured person would not be entitled to make a claim in torts, which has the force of law under the ESI Act. Even though the ESI Act is a beneficial legislation, the legislature has thought it fit to prohibit an insured person from receiving or recovering compensation or damages under any other law, including torts, in cases where the injury has been sustained by an employment injury.
Yes.
So, my lords, we are relying upon this judgment to show, my lords, that, as my lords rightly put to me, that it's a cautious liability.
So, and even otherwise means tort.
Yes, and therefore, my lords, NGT, my lords, the jurisdiction, my lords, the legislature would have had all these, the law in mind when they were enacting the NGT Act in 2010, my lords. And keeping in view that position, my lords, they have excluded workmen because Section 53 and 61 of the ESI Act specifically bars the person from getting any benefit. And NGT in this case, my lords, while granting compensation, says this will be over and above what is granted under the ESI Act. My lords, that's the respectful submission. Like I said, my lords,
there is any higher. So if there is no higher, this will it doesn't say over and above. It says if there is anything higher.
No, would my lords kindly
see that last part?
Yes, my lords, kindly see page 22. Yes, ma'am.
It's also very structured.
You know, my lords, they go by under the NACT Act, as my lords have given a multiplier factor. That is,
so what is the
what we are agreed by is the
idea.
Yes, my lords. We placed that on record that they are now being paid under the ESI Act.
Now, what would be amount?
Yes, ma'am. Yes.
If they have a higher claim, point is if they have higher claims.
No, my lords, the NGT, I wish had said only that if my lords would kindly see page 22, around 10 lines from the top. Any payment, my lords, if my lords has that, after they've computed it, and after my lords, what my lords have pointed out, however, if they have a higher claim, they can go there. But please see after that also, my lord. Any payment made, already made towards compensation for death may be excluded from the amount which is, but not the ESI scheme or the monthly payments under the ESI.
That will not be excluded, that will be taken into account.
My lords, so what they are saying is that this ESI Act will be paid in addition. And my lords, what we've done is we've computed this.
Any payment already made towards compensation for death may be excluded.
That's right.
But not the employee's deposit in insurance scheme or monthly payments. That will not be excluded. So which means that this will be included for computation of that total amount.
My lords, but then kindly see how it will happen. Here under the ESI, my lords, it's over a period of time that the money is paid. It's not paid in one time. My lords, under the NGT, if the NGT gives me a direction that to pay that amount, then my lords, that means that I stop paying the monthly amounts. It creates, if that is the issue, my lords. How we read it was, my lords, that the NGT is saying that this will be over and above. You will exclude the amount ex gratia payments that you may be making, but The ESI amount you will continue to pay. We've done a calculation, my lords, based on the life expectancy, etc. of the persons. If I may just pass on this chart, my lords, under the ESI Act.
My lord, say that over a period of 20 years or something, you pay this.
So, my lords, because this is, my lords, as my lords know, it will be paid monthly. It is idea is to, my lords, see that the person who was the breadwinner, my lords, doesn't leave the family in penury. And this is over and above compassionate employee.
What does that?
Yes, my lords, the first one who died, my lords, Mr. Abhimanyu Saha, the NGT has calculated 30 lakhs as compensation, my lords, based on
29 lakhs and the 229 rupees will remain the same throughout.
Sure. My lords, though, no,
What for the lifetime of?
she'll get around 30 lakh 69 if she survives till 70. If she survives more, she gets more.
What is the 30 lakhs over a period of time? 229 now and 229 10 years later.
So, my lords, there, under the ESI Act also, the government keeps coming out with circulars, my lords. There it may change. So, it's not that, my lords, it will become stagnant because the fund, as my lords,
Have you actually examined it?
my lords,
ESI, now many of them are getting just 1000 rupees, 1200 rupees, 1500 rupees. And coming from a public sector undertaking.
my lords, we have to, my lords, we are on the as my lords know, my lords, we are on the principle of law, my lords, because as employers, we need to be aware where all our liabilities lie. And here, my lords, the entity doesn't find that there has been any negligence. On the first date itself, my lords, we are called upon suo motu notice. My lords, we submit our reply. On the first date itself,
Where have you said where is your reply?
yes, my lords. My lords, my counter is at page. Sorry. Page 139, my lords, my counter begins before NGT. And my lords, there's one more error, my lords, in my respectful submission. The National Green Tribunal says these people are not workmen under the Workmen Compensation Act. My lords, that again I will show under the definition clause itself they
They
follow.
were contract employees. Question is, was this contractor
Yes.
authorized?
Yes, my lords, authorized and my lords, I'll show from the definition itself that even contractual employees who have been taken for repair work for a pipeline will be covered under the definition of workers.
Let's see.
Yes, my lords. Page 139, my lords, I was showing. My lords, first we mentioned the entire incident. My lords, how the incident took place. My lords, what were the safety protocols that we followed. My lords, will see at page 143 is the safety protocols that we placed on record, my lords. And then we pointed out, my lords, step by step what was the process that we undertook. So if I may just explain it, if my lords want me to.
Yes, Mr. Panda, what?
And last time, perhaps your lordships wanted to hear from the side of the workers. There is nobody who will be representing the workers. I am for the state police circle.
That's why we had moved them also application.
So perhaps your lordship may appoint some amateurs.
All right, we'll appoint Mr. Keshwan, you appear.
Yes, sir.
Please go into the matter.
Yes. Okay.
You have asked for the appellant, since she is Opium represented, in the press suggests that the matters is appointed representative, Mr. Keshwani is hereby requested to appoint, to appear and assist the court as a matters. Please give him a copy.
I will, my lords, provide any opinion.
If a book shall be provided for the applicant. This one after 6 weeks. You can file this.
I'll file this also.
That's appropriate.
Wait.
So there,
The principal passes on, another is on date.
What is the matter?
The issue relates to payment of my pensionary benefits. It's been stopped after 36 years of service because there is an interstate dispute in the college management and I am left in the lurch. Earlier, of course, my counterpart ought to have taken liberty by withdrawing the writ, but I would still make it good that there is a fresh cause of action. So that she wants to let it after the Passover.
Who is appearing for the, who
Yes,
appears?
I am appealing for respondent number 6. After filing of the Vakarama, we have no instructions from our client, so we will treat it as discharged.
That's all right. So, whom are you seeking Passover for?
For respondent 120, Mr. Dharmadikari appears with us. He is in another court. We have to pass this matter.
Passover.
Like the foreign assets, pension is the same. What is the first thing?
There is an item 49.
Has been dismissed as one. Shows the
The impugned order is because he withdrawn the earlier.
earlier without liberty. So, but I'll make it good that there was a fresh cause of action. The subsequent about your prayers. Prayers are almost similar. Bar one, when they said I wanted a narco test earlier, so that would be an abandonment. I've left that prayer.
Why?
I have totally missed
Why
it.
narco test?
I don't know, because there was a dispute among the management. So I said the current management is lying, so sent him for a narco test. That was my earlier round, which was absolutely misconceived. So that of course I have abandoned. So I'm more on my pensionary benefits.
Very
Well, okay.
I think 49 was done seeking a Passover.
49 and 40 petition.
Passover.
You are
So
for
respond 1 to 3 to 1 and 2 are present in court. My lord, the 3 and 4 are not in India. They have not been in India for a very long time. They are not. This is what my answer is.
Last time there was an order for them to deposit their
so that's all right. We want to know one thing.
The mother
We are asking them. What are the assets? Do we have an idea?
Yes, my lord, that is there along with the testamentary petition, isn't it? Can I just take it up?
You know,
In counter
corrected them and again.
Yes, we are aware. Let us also let's understand the totality of it.
An extra A of my counter affidavit, running page 11. I'm just pointing out, Madam, since I'm reading in this matter, since my lord is asking me, I'm just assisting.
Please.
Please, sir.
Now this, who is in possession of what?
My lord, my understanding is that Kirtinagar property is in the possession of the son. I am residing, I am my as the mother, one am residing in the F50 Radha Mohan. The rest of the property are not in my possession.
Now, see, this is as far as immovable properties.
Even for the movable properties, the
No, 1 minute.
yes.
2, 3, 4 are immovable properties. You are not in possession.
In the movable,
Sorry, 2 you are in possession.
2 are in possession.
1, 3, and 4 you are not in
I'll
possession.
just verify. Hello, sir. I just want
Just a minute.
The
I'm hearing
2
you.
and 3. The 2 and 3 we are in possession of. 1 and 4 we are not in possession.
1 and 4, you are in possession of 2 and. Then what about this Dubai? Dubai property?
Yes, that's right. Yes. Everything else is with the son itself, except those shares which are the subject matter of the present dispute.
That is, shares are mentioned there. Where are they?
Well, they are mentioned at page number 14, my lord, at serial number 1, which is the details of movable properties.
14 at number 1.
Yes. Everything else is in the possession of the son.
No. This particular shares for which we
Please.
in passing order.
Yes, my lord.
No, that is not in India.
They are not in India.
So you have control over that. You transferred it or whatever you did.
Your Lordship, the details of the shares are at page 13, item 1.
Spiritual developers private.
No.
It is late Shri Sudhir Kumar over here.
73,87,250 shares in Mezan Holding Company.
That's what I was
That is at counter, their counter affidavit, page 13.
serial number 1 of the
Serial number 1.
properties of Dubai, Kuwait and United States of America. That's what I'm also saying. And I have done a basic evaluation of the properties that are in the possession. Yes.
So number 1, number 2 and number 3 are also in your possession.
No, madam. In immovable properties, only 2 and 3.
Forget movable,
Yes.
I'm talking of movable.
For movable, only 1, which is the share in the Mezan Holding Company, for which this court is seized with the matter.
Then what about S overall?
Not with us.
You have it.
No, we don't have it.
You have it,
Yes.
sir. You have the position of shares in S overall.
Your Lordship, I am not sure, I will have to take instructions on that. But after the court order, I have not transferred anything in my name. That is a statement I am making on instructions, and they have done that. Why they have done that, if your Lordship will allow me a minute, I will clear that. But
To the testamentary proceedings.
Allowed it's still at the preliminary stage.
issues are yet to be framed.
Now, what is the next? What is your
And for an application for recall of 2 others, my lords, 6th May and 3rd of February. By order of 3rd February, my lord was pleased to issue bailable warrants against me, pursuant which I have appeared. My lord also directed us to deposit our passport and had put an embargo on us leaving the country. With regard to that, my lord, I am very willing to give an undertaking that as and when this court calls me, I will appear.
That's not the point. The
Please.
point is, each time you require your client to do something,
My lord, I understand. I understand I have the entire.
so we make sure that that part is complied with.
My lord,
That part is complied with, we will
My lord.
do everything that you need.
Please, my lord, for that,
We will not recall the order till you comply with that order.
my lord, that's why I have sought recall of both.
We will not, we will simply
Two orders,
dismiss it,
Two orders.
simply dismiss it on the ground that you have not, you defied the court.
Not at all.
We come back with the order, all kinds of things were said, that our court, the court there in Dubai doesn't permit, we don't know, or the company, the chartered accountant is, in charge of it, etc. We don't know anything.
Please, my lord.
Here, as far as, now it seems that you're now finding it a problem. So we will not pass any orders on this till you comply with it. And you will have, because you see, Ms. Juneja,
Please, my lord.
Ms. Juneja, the problem is, each time they have required something to comply,
Please, my lord.
a new council is.
Please.
So you are the latest in the
I understand, my lord, that's
Okay.
the audition. I seek the audition.
We don't know what assurance we can get from anyone, because each time the council says something,
Please, my lord.
unfortunately, he or she cannot live. You come back and face the court, or they replace the council.
Which is why
There
my,
is no assurance for
my
it.
lord, which is why my request was that the petition, respondents 1 and 2 will give their own personal undertaking before this court. First,
We
second,
are not concerned with undertakings. We
Second, I
are
will
concerned with first, some substances. Tell us how to ensure that these properties secure.
please, my lord. With regard to that, I will just point out the order of 6th of May 2023 is the 22 is when this honorable court had directed monetization and the registry, positive registry. At that stage, an impression was given to this honorable court that the respondents herein are evading service. I can place an additional affidavit on record along with all my documents to show that respondent number 2, 3 and 4 were not even in the country between that entire period when the service is set to have been effective.
But still, service is done.
It was only done in August of 2023.
whatever it is, your responsibility is, once you are aware that this is the order, to comply with it. The monetization has to happen. After that, we will grant you all the relief. You do it, till then we will not do anything. So take your instructions if you want.
I'll also keep it for Friday.
Why Friday? You keep it, you take your own time to comply.
Well, I will keep it for Friday. I will come back with proper instructions on all the orders and the directions given by this honorable court. Whatever legal impediments I will have, I will place those also for this honorable court.
You don't even know whether you will come back.
I will be there.
Your Lordship may allow me 1 minute only.
Yes.
Why it is happening? Why it is happening?
Excuse me, sir. See, this boy need to call the property in Dubai. He encashed it. He took my house, 6-bedroom house. Number is 715 District 1. He took that also. And
He's your son.
Biological son.
I can't say this is my son. This type of son can't.
You see, Ms. Ura, you may have your problem. We have
You know what?
difficulty in understanding that there is a problem.
He stands.
Only thing is, we want you to comply with the order. Once you comply with the order, we may actually call that your son also ought to be present here.
Please call him.
So
Please.
we will not do it at your dictation. You will have to comply with our order, then we will do what we think is right.
You please call him because.
We will not call him till you comply with the order.
Okay. And second thing, he sent the police in my home, and being a senior citizen, I didn't get up in the morning. 7 to 8, 6 people came to my home from the police station. They are troubling me. Please stop this and just tell them not to do like this. I am an elderly lady and my legs are not working. I told you last time also. Please help me.
She has deposited the passport.
No, my lord, with regard to
you
that,
should
the travel agent also. What had happened is the respondent number 2, her son stayed in Switzerland. It was his birthday on the 16th of February, because of which she had given the passport for Sheridan visa, where after this order of this honorable court, she asked for it back. I had that letter from the travel agent also. I can show to my lord that I had given it to the and which is what is happening.
We are keeping it on Friday.
On Friday.
You will come back and deposit if you have not deposited.
Your Lordship, one submission only. First, Your Lordship, the office report says, today's office report, the report from the police is that they deliberately did not deposit the passports, and on the premise that we have given it to the travel agent. We all travel to foreign countries, original passport is never given to any travel agent. VFS service, yes, it is given, but never to a travel agent, that is one. Now, Your Lordship, why they are delaying? In my rejoinder, at page 3, I have highlighted how the shares of this company are going down and the estate is depleting. And at page 8, Your Lordship, I have said that last year they have taken approximately 2.8 crores of dividend, about which they do not speak a line. And in another 3 months, another installment of this dividend is likely to come. They want to wait for that and pocket that. In defiance of the orders of this honorable. Only two.
This is the sad state of affairs where the son is suing his mother for the properties of his father, late father. He's not even had consideration in that regard. Only that is all I'm saying. I'm here.
I tried to contact on 18th of January. I messaged my mother. She did not respond even. It is not so. It is not that. It is not correct.
Let them comply. Please, we will tell you one thing.
Please, Your Lordship.
Well, they are all blood relatives. So we will take
Mother and son. Sorry, Miss.
I don't know, what is your age?
He's 37, 38, my lord.
They are 38.
38.
So if we are not satisfied, we will simply dismiss it. Okay? Now, we may at some stage require you to come and be present in the Delhi High Court, because who has filed the test?
Both of us have
Both have filed.
Both of you should be present.
My lord.
Your Lordship, we are.
Oh yeah, इतना time नहीं होगा. Do it.
Wait, the other one is letters of administration.
Both of the ways.
Both
Across
There
probation.
are two ways. So.
2 ways.
One is a 2000.
One is in my favor, that is a registered will, and 26 days before the death is another will in her favor,
That's
which means which we dispute each other.
which will show the true state of affairs, my lord, as to why the father had to reach that situation.
Depending on what they do, we may actually not even exercise our jurisdiction. We're telling you in advance. Because this is after a point of time, this is after all a contempt. A contempt you come in appeal. And how far we can take it, we don't know. So please keep this in mind. We will ensure that there is compliance with our order. Thereafter, what we have to do with you, we will also take care.
Lordship, I am ready for all things. I am ready for expeditious.
Not expeditious, you may have to be present here in the court, in the High Court, going for some kind of mediation. This is not.
Lord, may I request if that's
Maybe you are right that they have not done this. This is not our way of dealing.
If your lordships will desire that, we will do that also. We will go for mediation as well. If we desire that, it is physical, there is no problem.
Necessary, I may file it in the meantime to my lord.
It is open to the respondents to file additional affidavit.
May I also request if the mother can be exempted from personal appearance, the daughter may be exempted.
What is the name?
Miss Neelam Oberoi.
Is hereby exempted from personal appearance for the family.
Much obliged.
Thank you, sir. I have one request. If you won't allow me to come here, I can't come.
We have done that.
Okay, thank you. Thanks a lot.
Obliged.
On the last occasion, my lord has asked me that if my lord, something can be worked out within the parties. I have actually spoken with my client, who is the husband, my lord. The Honorable Trial Court has actually directed the maintenance amount of rupees 10,000 per month to the wife. And the Honorable High Court has, my lordship, reversed the finding and has allowed my appeal. The wife is already having 5 acres of the land, and I also filed the revenue report, which is also a part of the trial court. My client says that 5,000 can afford to pay, because it's not the position that she's like completely empty now. If my husband agree to that.
Lordship, may I submit to your Lordship? Lordship, if your Lordship will kindly see the finding reported by the trial court. He has around 45 to 50 acres of land, your Lordship. It is a case wherein before dissolving marriage with me, he has entered into second marriage. Now what the respondent is doing is, your Lordship, he is transferring all his land in the name of his son. The amount of maintenance which has been awarded by the trial court is 5,000 only, your Lordship. I must agree to that. But if your Lordship will kindly see the situation. In 1982, this party got married, your Lordship. She stayed with the respondent only for 2 years. Thereafter, he has thrown her out of the house. He has entered into second marriage. Now, till my father was alive, your Lordship, I was dependent on my father. My father died, giving me 5 acres of land. That is an admitted fact, your Lordship. I must admit this. But that land is being cultivated by my brother. It is not in my hand because I am not in a position to do cultivation. It is only after my father's death, your Lordship, I will file an application for maintenance, seeking maintenance from the respondent, because there is no one to take care of the petitioner presently, your Lordship. So awarding 5,000 rupees would be very less, your Lordship, even if we compare with the status of respondent, because there is a specific finding which has not been controverted or rebutted and by the respondent. Even the High Court has not given any finding contrary to this. If your Lordship will kindly turn to page 53, this is the finding recorded by the trial court, wherein it is specifically stated, your Lordship, that he has around 43 to 44 acres of land. Respondent. Even then,
the income out of the land is also mentioned, my Lordship. It is not a city, it's a very rural area. The total
it's an agricultural land, your Lordship. The very fertile agricultural land.
animals kind of
I think it's
crop.
hardly like in the name.
Yes,
Yeah, so it is 7 lakhs a year. It is 7 lakhs a year, my Lordship.
18 quintals, 1800 quintals of paddy.
Into 7 lakhs.
1800 quintals of paddy is harvested
And
in 40 acres of land.
see the other aspect as well. there was an agreement, and when I would see at page number 21 of the SLP paper books, what section 125 clause 4 says that if the party mutually decided to live separately, the spouse cannot claim financial maintenance if the parties are mutually decided to want to be separately. In fact, there is a two High Court judgment which also says that if by way of an agreement, the parties decided to live separately, then the wife cannot claim maintenance. Although there is no Supreme Court decision on the point, but if my lord would want to,
there is a Supreme Court decision to that
no High Court judgment with me, my lordship. The other aspect is that, my lordship, after 14 years they have entered into the agreement that they will live separately and that they will not
When
file any.
when did you get married?
1982.
No. Second marriage.
2010,
Marriage I don't know the date, my lordship.
Your Lordship, it's recorded in the trial court order. The marriage, he entered into second marriage in the year 2002, and the compromise, the so-called compromise agreement was executed on 24th.
The trial court.
Yes, sir. The 43.
He must be parties living in the village and they belong to the OBC category.
Page 43, top
Page number 43.
the applicant, the non-applicant, Your Lordship, has to be from page 42 it starts, Your Lordship, bottom. It is apparent that non-applicant had formalized second marriage prior to sending notice year 2002. Therefore, applicant has not mentioned the fact of second marriage in the notice exhibit issued to the non-applicant. On this basis, this statement of non-applicant that non-applicant solemnized second marriage after proceedings of dated 24/3/2003 does not appear to be true. This is a clear finding of the trial court, Your Lordship. Then, at paragraph 29, the learned trial court recorded a finding that the marriage cannot be dissolved merely with the consent of the party. There has to be a decree of the civil code, because the respondent has not given any evidence to show that in the Patel community there is a custom that the marriage can be dissolved through consensus.
When was this agreement of 20 lakhs or 10 acres?
It was oral agreement, my lordship, and it was for the trial.
It was on the date, Your Lordship. The contention of the petitioner is when this compromise agreement was executed, it was assured to the petitioner that
1980s.
No, 2003, Your Lordship. 2003.
Where is that agreement?
The agreement is not on record.
Maybe oral one of the assumption which the
Mr. Shukla, there are two. One is obvious, we will not interfere or we will ask you to pay some. The other is we will go into the merits and restore the trial court judge. Then all your contentions are there. He can actually get maintenance from you.
The Balaji is completely ordered in a lot, my lord. But there is only
What is actually exhibit D2? Is there?
Your Lordship, it is not on record, it is not filed.
You must be having a paper book, record paper book with you.
Your Lordship, it is reproduced in the impugned order, Your Lordship.
Only referred to.
Only the part.
The order of the manager which is under challenge is agreement.
My lordship, in the counter affidavit at page number 11 is the agreement in English, my lord.
Page number 11.
Yeah, it is the agreement between the parties. I mean, it is the same agreement which is reproduced in page 4 of the High Court order.
Yes, page 11. No? Page 11 of the no.
Page number. So, my lordship, the agreement says that no party will have any claim against each other. It is, my lordship, one-time permanent alimony. And my lordship, as per section 125 clause 4, the party mutually agreed to live separately, and therefore there is an invalid option if one
There is a finding against you that you got married prior to this. That finding has not been completed or even set aside.
Okay.
In your Lordship, there is a judgment of this Honorable Court which says that such a compromise will not prevent the wife from 2014, Your Lordship.
That's the only thing we can do. We will set aside the High Court judgment.
And I propose 1,000 rupees a month.
No, you come out with a better offer.
I will, my lordship, because you
You
know,
and then see what land you can give. Otherwise, one has other ideas also.
in fact, my lordship, on the aspect of land also, we have to discuss that because she knows the position.
Otherwise, I have other ideas about the land.
I will even if my lordship can also come up with a figure, I can also put it to my client.
Your Lordship, on the last date of hearing, an amount was asked me, Your Lordship. I took an instruction. What has happened, Your Lordship, will take a lump sum amount now. Then after 5 or 10 years, that amount will go and again I'll be on road. Then again I'll have to file an application for maintenance.
Just find out what you want. What do you want?
But I think it's not
If you want land or something, that too can be done.
Your Lordship,
Then again the same problem for you.
Exactly.
Your Lordship, may I have it, Your Lordship, after the holification in any day? On a fixed date, Your Lordship.
Yes.
Indeed, too.
Okay.
I'm representing the petitioner. As per the court's direction, the petitioner joined the investigation both on Friday and Saturday, and his statement was also recorded before the jail first class Palwal, and his signature was obtained on the statement as well as the some. He has joined the investigation on 24th and 25th month. But so far as the earnest money is
He has joined, so what is the point now?
But when the specific question with regard this earnest money which he got, he refused to get it recovered.
Do you mean this is a recovery proceeding?
This is a matter of my lord. I have on record case. This is the my lord. I have on the investigation. I'm for this state.
And for the complaint, I had to submit something. But what has happened is after he did the agreement to sell with me, immediately he sells it to somebody else, even before the expiry of my date, and then claims to have gone to the
This may be able to 406.
my money is used to pay back the loan which he has taken from the bank. And then after having paid the bank, what he does is, the present sale which he does the second time out, he sells the same property for 1/3 of the price. He tries to sell it, the property to me at 1 crore and 50 lakh, and then he sells it at 49 lakh to somebody else. Only to avoid frustrate my contract. And that's how I allege that this is a sham transaction. It is more than a conspiracy also. But I'm just pointing out the fact, not to.
Lord,
Just wanted to point out the conduct of the.
Lord, if I'm allowed to say something, I will take 1 minute of the court's time. My learned friend in his counter affidavit on page number 5 has alleged that before the expiry of the date or supposed date on which the sale deed was to be executed, I already entered into an agreement and took a check on 8/9/2021. No, that is a completely baseless and false allegation.
Anyway, we are not getting.
But for that I have the proof that I received the money after the date of the expiry took place. So I have
Just take the court violation notice and require the petitioner to report to the investigating officer. So, learned counsel for the state suggests the petitioner complied with the direction and has joined the investigation. So, having regard to these circumstances and the fact that and the nature of the offence alleged against him, petitioner is directed to be enlarged on bail subject to such terms and conditions as trial court imposes. Petition is allowed that.
in future also if you cooperate with the definition of I will do that.
Such terms will be imposed.
Grateful.
Yes.
Lordship, the petition before the Lordship is seeking NCT secretary bail. The petitioner is a 25-year-old boy who is preparing for government services.
Yes.
Lordship, the FIR was lodged on 18th November 2021. Thereafter, I had joined.
What is the allegation against you?
The allegation is that the complainant's nephew wanted to get selected in the examination to be held for the post of Patwari, and for that he came to me and my brother-in-law and paid us 18 lakh rupees. And we sort of represented to him that we will arrange a job for him. But it is totally false, Lordship. I am a boy who is myself is preparing for government job, and I have never contacted him for this money. And I have basically cooperated with the investigation in Lordship will see. I have attached a letter at page 36 where I have given the details.
The FIR is lodged in October.
November 18th, November 2021.
We are not inclined, sir. We are not.
Lordship, there is a boy of 25 years, Lordship, his entire career will be
Go
going
back
on.
and apply. Notice. Notice made out, special.
Lordship may see the letter at page 36. Lordship, I have enjoyed the investigation. Lordship, see the allegation, it's under 40640.
They will not arrest you. You submit to them, they will not arrest you.
Lordship, if Lordship will consider putting me to terms, Lordship, to show my followers I am ready to deposit for anyone.
You go back.
Item 53.
This.
Yes, please, because we have filed just to respond to what your lordships had a concern about. We have filed this additional document to the lordship. It's not a copy of that.
Yes.
I'm going to show you three things from that lordship. First page is page, sorry, you know.
Yes, we have.
I'm sorry. Page 24. Sorry, just give us. Give us.
24.
Yeah.
No, 24. Only 7. So you can.
I'm sorry, we have.
There is one additional affidavit.
Yes, so this is over the weekend. When is this time? I'm sorry, my misunderstanding. This is being handed over by me now.
That thing was filed earlier.
That was with the original petition itself. Yes. So there are two things I'm handing over. One is that compilation. The second is this annual report. And this annual report, I'll just address that first. Give this to Alison. This annual report, my lords, is of 2017-18 because your lordship had asked us that if this 2 lakh odd number, the majority of them would be those who had qualified much earlier and the inconvenience being caused to them. The lordship can come just to the absolute last 2 pages of this annual report. These are those who have been recruited in undergraduate by me, who are the ones who will be graduating this year, who are the ones on internship by client services. So if you see the last 2 pages, second last page your lordships come to, it shows the state-wise details of medical colleges and MBBS seats for annual year 17-18. At the bottom, if you see the total is 67,352. Extreme right, bottom. So maximum, if every single one of these people decide to sit for PG, it would be 67,352. The remaining 1,33,000 or 35,000 would be those who had in fact graduated already in previous years and who have not been successful in their PG admissions. There are a large number of them. We have annexed in fact the refund document, the refund letter. The page 30 of this compilation of the lordships can have. The other one was, now we can leave the annual report aside. It's just to tell your lordships who might be in the fray.
Yes.
In that page 30, this is 24th February, on Friday, when this matter was last heard. This notice is by the DGHS and it mentions in the first paragraph, it is for information of all candidates who participated in PG 22, last year's PG, that as per the eligibility conditions of refund, the refund of the security deposit made to 60,874 candidates. Please find refund this. So these are candidates who took part and who didn't make it through to PG. Either they weren't counseled through or they were not successful. So 60,874. So there is a large chunk of these who are likely to be in that 2 lakh who have registered themselves for this exam. And there's obviously some more who may be from previous years, etc. This is
You, so what is the inference you want us to?
and one more which is page 24.
Yes.
Page 23 and 24. 24 if your lordship first sees. This is a list of all the states and their internship deadlines. Please read the notes at the bottom. I won't trouble your lordship with that table.
Yes.
As per 7 January 2023, there is the initial notification which kept 31st March as the deadline. With internship cutoff dates at 31st March, except for Andhra and Haryana, no other states became eligible. So it would be only that small pool of whatever colleges there are in Andhra and Haryana who would have become eligible. Even as per 13th January, which took it up to 31st June, the internship cutoff 30th June, Telangana, Madhya Pradesh, Pondicherry, Jharkhand, Bihar, Chhattisgarh would be ineligible. So now with 11th August, in fairness, I must tell your lordships that there are 2 states which still stand excluded. One is Jammu and Kashmir, and the other is Chhattisgarh. Therefore, the deadline that they have now of 11th August takes care of everything. And if you come to the previous page, 23, we have shown your lordships the previous years what the practice has been. The internship deadline has been 31st March 2017 and the exam date is given there, 5th December 16. This is what the practice has been in the past. The gap between these are never more than 2 or 3 months.
Which one are you?
Page 23, I'm sorry. The table at the top of page 23. If your lordship sees between internship deadline and exam date for all these previous years, very small gaps in between.
What you are saying is they ought not to have postponed the internship.
I was afraid you don't perfect activity. It's not unusual, my lord. Or every time in the past, only 2-3 months gap used to be with the last date of internship. This time the last date of internship, which for before counseling, is 11th of
That's because this is unusually they are postponed. How many times they have postponed the internship date?
Twice.
No, not today. In the past, if you have been able to get
So
data.
last year it happened, same thing happened last year.
What they did this time was, when they allowed the first date, they didn't consult the states. So majority of the colleges were not covered. So they enhanced the date, brought it forward. Again, states were not covered. It's the third date which brings 16 states. And these students of 16.
So last years, when did they increase it?
So that chart, say page 23, sir. If you see the below chart, the chart below, these are instances where that exam has been rescheduled. If you lordship see the middle one, Neet PG 22-23 and Neet PG 21. Neet PG 22-23, earlier proposed date was 12th March 22. It was postponed to 3rd, it was postponed on 3rd Feb to 21st May 22. So by 3 months it was postponed.
What was the reason for postponement?
This is at page 46 of the main SLP. It is a notice by the authority itself. They've said, keeping in mind that many of the interns would not be able to participate, page 46. of the main SIP, not this volume, main answer. Postponement of Neet PG 22 regarding, I'm directed to say that a lot of representations were being received from medical doctors regarding request to delay Neet PG 22 examination date, that is 12th March 22, as published in Information Bulletin so and so, since it is clashing with the Neet PG 21 counselling. Also, many of the interns would not be able to participate in the PG counselling 22 by the month of May or June 22. Keeping the above facts in view, the Honorable HFM has taken the decision to postpone Neet PG 22 by 6 to 8 weeks or suitably. Hence, the decision made by Honorable HFM may be complied with. Lastly, my lords, in the SLP itself, page L, if your lordship can see, there is a table at page L. Lord Justice Datta has. So, page L shows the previous years, the date of exam and date of counselling. If I take the first one, January 7th, January 18th is the exam. Counselling is March to May. 6th January 19th, then March to May. 5th January 20, again March to May. So it's all just 2-month gaps. Right now we are looking at a gap of more than 5 months, all the way till August. And maybe even longer, depending when the counselling winds up. There's no particular purpose.
When you make the request for postponement of internship eligibility, you are doubtless aware that
None of us did, to be fair. Those requests were made by others, but not
by you meaning you as a class.
yes, large class.
When that means you are ready right now. If you had not made this request, then you are ready to take the exam. You were ready to take the
I
exam.
presume those who made that
No,
already.
since you are there before us, you did not make the request for postponement.
No, but
If you have not,
yes,
there are two parts.
no, I have.
If you did not make the request, then you are ready to take the exam, so nothing has changed for you. So those who have made it, now you stand for
We're
some
not
of
in a
them.
position to take the exam until we were. So until 7th February.
No, again,
We were not
I'm sorry,
ready for the exam.
I'm confused. When I asked you whether you wanted postponement of the internship date, you said we did not want.
We did not
You
apply.
did not want.
We didn't make the representation.
You did not
Yeah.
want.
No, I'm not. I would say
No, wait. If you did not represent, you were willing to
yes, I
write
did take
the exam.
representation. No,
That
we
means some of you whom you stand for,
yes.
were content with the date as it stands.
We did have choice because when your lordship says content, that means that I would be getting the opportunity to sit for the exam. I wasn't getting the opportunity. When I was given the opportunity on 7th February,
Essentially, you are content with the situation as it was.
that is the way of looking.
That I was not getting
No,
it. I am reconciled to the fact that
That is the way of looking at it. I can't argue with that. That is true.
So which means that 31st March, whatever it was.
Correct.
Very well.
If I did represent, then I was keeping quiet about it. I was waiting for my
When did your internship start?
different dates because of
I
us.
take it that it is 6 months. I mean,
Could have been.
1 year would be over on 11th, which means your internship is a year, isn't it?
In May, June, July is when our internships will be getting over for those who are before your
All right. So otherwise, which means that it started in May or June.
Yes,
So when the advertisement came out, you were just halfway through.
correct. No, so Manoj, all I'm saying is, I'm sure there must be arguments as to why the exam should happen on that day. I anticipate that my friends are going to say that look, admit cards have been issued this morning, 27th morning, and that we spent a certain amount on the test centers, etc., so don't push it in. I'm looking at it from the other side. I'm saying that
I'm only trying to ascertain that
Yes.
what do you mean by saying that this 60,000 or whatever number are the only people who are concerned? But you said, so what is it that you argue? That there is a
No.
balanced number of people are there.
yes.
Those balance are kind of
No,
people who have not made it, so why should we bother?
No, I'm not saying that. I'll just explain. Because 2 lakh odd have registered for this exam, the lordships on the last occasion have been concerned that many of them had just completed their internships, they were preparing.
We never said that. We were concerned that there could be people.
They got a sizable number.
There are different classes of people.
Correct.
Some of them, many of them may not be fortunate enough to just get in Many of them will not be fortunate enough to sustain themselves,
That is
right?
No, absolutely.
You have
All I'm
to
just-
sustain yourself, so you may work for 2 years.
We will just
and then
try-
start.
No, I'm
I'm
just trying to assist your lordship. I won't have the exact number. I'm just trying to assist your lordship that the classes of people who fall into this 2 lakh award, there's clearly a sizable number, perhaps the majority, who are not those who have completed or are completing the internship this year. The majority, because the maximum that can be
The
67,000.
trend has been, perhaps the pattern has been that
Yes.
those who complete that year
Yes.
may not be, there will be a sizable number of people, but they will be
Yes.
not the majority in any case.
Correct, but last year as the lordship saw, they said that we are extending the date so that we can get more people into the pool so that the internships can be completed.
As you noticed, last year the extension of the internship was never that long.
Typically 6 to 8 weeks. That's it. Now,
Today,
yes,
there are two things happening.
yes,
When you, as they say, when you pull the cloth this side,
yes,
and something happens this side.
yes.
So how do you balance it? How do we balance?
No, I agree. I know it's not a simple thing that you're asking your lordship. All I'm saying is, like I mentioned last time, that if the counselling is any case going to take place after the 11th of August at the earliest, it may take place even in September, October, knowing how it is, there may be litigations, it may drag it out more. Is there much advantage by rushing this exam through at this date when, like last year, even 4 to 6 weeks or 8 weeks, it could be postponed? That's all I'm saying. Is there
Right. Yes, Miss. Who else? Mr. Kanka is here. It is not there.
No, sir. He is in code 3 right now.
What is it? No, we can't look there.
No. Item 43 is
Yeah. Yes, but
Would your lordship consider allowing us to give these facts?
see what he is saying. To some
Madam,
extent, you see, is first look into all.
Madam, I have given some dates.
Same.
First thing, your lordships will see that the exam was announced, Madam, 6 months back. On 16th of September, the date of this examination was fixed, Madam. The second figure we have, Madam, so all this contemplation is not really necessary. Everyone who applied in the first window is 2,03,000. So it's only 5,370 students who have applied in the second window, which was reopened between 9th of February 23 to 12th of February 23. Lordships may now kindly come to point number 2, Madam.
So, according to you, 1,76,000 complete by 31/3 is original date.
Yes, Madam. 27,232 complete by the first extended date, and only 5,370 are falling in the second extended date. Madam, but your lordships will note, Madam, that the date of examination was fixed 6 months back, Madam. Please also note we've given for the last 3 years, but my colleague has already shown that to your lordships. Please see serial number 2, Madam. This is the total number of candidates who have applied. Admit cards have been issued today as scheduled. So admit cards are issued, Madam. Then we have made a chart of the 10 petitioners who are before your lordships, Madam. 17 petitioners who are before your lordships. Your lordships will see that out of these, more than 10 petitioners, 10 petitioners have completed their internships last year or even before that. Lordships may kindly have a look at that
We
chart.
will not look into that part. We take it's like that, but we treat this as more of a class.
But your
That we
lordships may still see that it's only 3 petitioners at serial number, kindly have that chart, Madam, which is annexed with this. It's only serial number 11, serial number 13 and serial number 14. These 3 petitioners who fall in the extended period of internship, Madam, who will complete it only in August.
No, 14, even 15.
No, 15 will complete by May, so they fall in the first extension. Your lordships will see that the date was extended twice. First it was extended to 30th June and then it is extended to 11th of August. Let's kindly also see, we have now a decision on when the counselling will start. Serial number 4, your lordships will see, my lords. The counselling will commence on 15th of July 2023. Approximately 98% of the participating doctors will finish their internship. Serial number 4 of my note, my lords, the status note, serial number 4. So, my lords, we want to start counselling by 15th of July 2023 without waiting for the August date. This will accommodate 98% of the participating doctors. They will finish their internship by the time counselling will begin from 15th of July. Remaining candidates who complete their internships after 15 July will be eligible to participate in the counselling provisionally, and they will be dealt with on a case-to-case basis. Then after that, they will be required to complete the PG tenure of 3 years, etc. My lords. Then preparation, point number 5 is with regard to preparation, my lords, that has already been made. My lords, I have already pointed out on Friday, your lordships will appreciate, my lords, that a large number of my lords, administrative preparations have to be done, which is all in place, my lords. And most importantly, my lords, there is no date available in near future with our technology partners, my lords, to conduct a Neet PG exam, my lords, and your lordships will view this from the point, my lords, that we are trying to put the calendar back into place, my lords, after suffering 2 years with the COVID delays. My lords, this has impact on availability of
Shankar, yes, on this chart that serial number 10, yes, completed his internship in 2017. That is correct. Right? Yes. You remember on the last petition when you.
And then look at number 7.
2030. No, 2012, correct. Now you submitted that 45,000 would be ready to join you. Yes. Right? Yes. But if you go by the figures at paragraph 1 on page 1, yes, 2,03,000, yes. Out of 2,03,000 who had applied, 1,76,000 yes, would be completing their internship by cannot be right because I showed you that 45 cannot be right. No, I'm saying 1,76,000 completing their internship can't be right because I showed you the annual report which says 65,000.
They're all inferential. This can't be right, can be right is for us.
No, I'm sure that if they have only 67,000 students, how 1,20,000 can be completing the internship, I don't know. I don't know, I mean, maybe 1 year. Yes. It starts from 2013 onwards. Yes. So the internship you have to take from 2013 onwards.
We have one hard figure, which is 5370.
Yes.
They are the fresh numbers.
Yes.
Beyond that, we don't have. So there is a question of 45,000. That's for sure.
Sorry.
So therefore, there's no debate on that.
But no, I didn't have this data because I only put conjecture.
That too.
Only they have the data.
You're right.
No, whichever way this goes, I have only one suggestion. They have said that they will start, and this is not with reference to my clients, they have said that they will start their counseling from 15th July.
Yes.
Just logically, it doesn't make sense to start from 15th July if they are going to counsel those who finish on 11th August. After 11th August.
According to the estimation, 98% would be covered by.
No, it may. I have no doubt that it will. All I'm saying is that if you do that, suppose the person who finishes on 11th August is the first client in the entire Neet PG exam, what happens to him?
Nothing. He gets it.
How will he get it? But he won't be part of the counseling.
He is. Please read it.
Yes.
He's provisionally part of the counseling.
Plus, it requires their own rules say that you have to come with the internship completion certificate. If they don't come with it, let them relax that rule. I don't know. This doesn't concern my clients in the least. I'm just saying, if this is what they're planning, then I don't want another glut of petitions saying you said internship completion certificate. So we're doing this.
So we'll do the best we can under the circumstances to not say anything, let things lie as they are. One can understand, you see, it's a very hard decision.
No, it is.
Because I mean, there's no adversarial effect.
No, absolutely. So I wouldn't press it further than what I have.
Let's leave it at that. You've done the best that you could.
No, just one last point here. He raised it very well, but I'm re-emphasizing.
Yes, yes.
Lord,
They were not looking at you there.
so that I went running to the side.
Yes.
Sir, what I'm trying to say is, sir, for every candidate who finishes first, second, third, fourth, his subject and college is very important. I mean, they're actually fun. That's their life. Somebody wants
right. Somebody wants
I mean, without getting into figures, because we are not authors of figures, and we will not even know the authentic figures today. But the fact is, a lot of candidates will still not have the eligibility to who may be first, second, third, fourth, fifth, to come for their first subject and the first subject.
Understand. I mean,
No, there is a difficulty.
no, not just that. There are too many
Pitfalls.
too many people to contend with, and some of them may have, like you said, I mean, you look at it from one perspective. You've not made it. There is nothing in this world to prevent somebody who has not made it to try again, or they could take any number of efforts. Maybe even this 2012 person, he may have had his own constraints, he's waiting. Or likewise on the other side, there are people who have been waiting. That's not to say that they should not have a chance. So who would have prepared? Now,
Sir, this became acute because of Neet. First, every state used to have its own exams. Today, this is one date for everybody in India. If you are not accommodated on these days,
right or wrong, all this is a part of the evolutionary process. Sometimes evolution gets it right, sometimes it's wrong. Now you have to take it as it comes.
So what he was actually requesting was not about so much of counseling.
No.
It was more to do with the shifting of examination date.
Right.
That's
the whole claim in this.
If instead of March, if the examination date was April, the people who were selected.
But for the fact that
16th
with the lives of people, one could have even said, alright, you were nowhere in the picture.
No, 16th state, but not in picture. Till the last application.
Nowhere in the picture. Many of you were nowhere in the picture. Haven't gotten into the bus or the train, now you want to get.
So we are actually what the student told us was.
No, I appreciate. We understand. Lot of people, they're waiting for this. A lot of answers.
Yes, it's their dream. It's actually their dream to sit for
we don't want to feel it yet either. So we will not say anything. We will just let it lie, and we're not entertaining this. And your counsel,
I'm the agreement party from Telangana State, my lordship.
You are the means you represent it.
My lordship. I'm representing from the Telangana State, my lordship, and we are going to impede from the petition, my lordship.
We are not entertaining the business.
Grateful, right?
Grateful.
Please on. I'm asking for Lordship,
Item 8. We're in item 8.
Yes, sir. Item 8, sir. What is the petitioner is seeking bail, as he has been charged for the offences under section 376D and 4 and 8 of the POCSO Act, Lordship. The petitioner has served with more than 3 years. Come to paragraph